Hello guys, I'm Shreya and I welcome you all to my channel Knowledge Info. Today in this video we will discuss about criminal conspiracy. We will discuss sections covered under criminal conspiracy, why criminal conspiracy is punished under IPC, its ingredients, some of its features with some referring case laws and lots more. So without any further ado, let's move towards our video. First we will discuss what is criminal conspiracy. In general words, criminal conspiracy is the agreement of two or more persons to do an illegal act or to do a legal act by illegal means. This was held in Rex vs. Jones case that criminal conspiracy ought to charge a conspiracy either to do an unlawful act or a lawful act by unlawful means. It means when two or more persons with the meeting of minds agree to do an act which is illegal in nature or they agree to do an legal act by illegal means. Here I would like to explain which act is known as the lawful act by unlawful means. For example, when two or more persons went into a jewelry shop to shop some jewelry items, but after going into the shop, they dropped the plan of shopping the items. Instead, they decided to steal the items. And when at the point they decided to steal the items instead of purchasing the items, the act was converted into an illegal act, which is an example of a lawful act by unlawful means. Here, shopping of the jewelry items was a lawful act, but it was done by the persons by using unlawful means, which made it an illegal act. It was also held in Mulaki vs. Regina case that criminal intent of doing an act is very indispensable for constituting the act of conspiracy. It means through this case, the court held that the criminal intention is the must for constituting the act of conspiracy. The accused person must possess the criminal intention behind committing the act of conspiracy. It means that according to this case, criminal intent is must in constituting the offense of criminal conspiracy. This means the parties of conspiracy must have the criminal intention while doing an act. Criminal conspiracy is contained under Chapter 5A of the Indian Penal Code 1860. It was added in 1913 by the Indian Criminal Law Amendment Act 1913 to make criminal conspiracy a substantive offence. It means that criminal conspiracy was not contained in the Constitution since its very inception, but it was gradually and eventually added in the Constitution through the Amendment Act of 1913 to make criminal conspiracy an independent offence. Only two sections are contained under criminal conspiracy, that is section 120A and section 120B, in which section 120A talks about the definition of criminal conspiracy, while section 120B talks about the punishment given under criminal conspiracy. Now we will discuss about the definition of criminal conspiracy which is given under section 120A of Indian Penal Code, which says criminal conspiracy is defined as an act when two or more persons agree to do or cause to do any illegal act or any act which is done through illegal means, which means according to section 120A, when two or more persons commits any unlawful act or any illegal act or any legal act which is done through illegal means, then it amounts to the offense of criminal conspiracy. Now we will read one proviso which is given under section 120A, that no agreement except an agreement to commit an offence shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. It means that not only an agreement which is made to conspire a particular offence amounts to criminal conspiracy, but also any act which is done in pursuance of such agreement also amounts to criminal conspiracy, which is done following such an agreement also amounts to criminal conspiracy. Explanation related to this proviso is as follows. It is immaterial whether the illegal act is the ultimate object of such agreement or is merely incidental to that object. It means it is not important whether the illegal act committed by the accused person is the final objective of such agreement or is just performed in pursuance of such final objective. Both will amount to the offense of criminal conspiracy. Now we will study about the ingredients of section 120A of Indian Penal Code 1860, which is required to constitute the offense of criminal conspiracy. It was held in Rajiv Kumar vs. State of UP. The court took out some basic necessary ingredients in order to constitute the offense of criminal conspiracy. which are as follows: that there must be two or more persons. It means that two or more persons are required to commit an act of criminal conspiracy. Second is there must be an illegal act or an act in an illegal way, which means that there must be an illegal act done by the accused person or an illegal act which is done in illegal way by the accused person. Third is that there must be meeting of minds. It means that parties to the criminal conspiracy must have the knowledge about the act of conspiracy. Fourth point, that there must be agreement regarding the same thing. It means that the parties to the criminal conspiracy must agree regarding making the plan of criminal conspiracy. In Pratap Bhai Hamir Bhai Solanki versus State of Gujarat and another, the apex court held that the most important ingredient is the intent to cause an illegal act, which means that the Supreme Court held through this case that the criminal intention possessed by the accused person is must to constitute the offence of criminal conspiracy. Now we will discuss some of the important features of criminal conspiracy or some of the important attributes of criminal conspiracy. First is knowledge of the objective is necessary. It means that there must be existence of the knowledge of the object regarding the commission of the conspiracy. It means that the accused person must have the knowledge that he is going to commit the act of conspiracy. Second point, criminal conspiracy can be a conspiracy of an offense or an act which is forbidden by law, and also for a civil wrong, which is the meaning of the term illegal as provided in section 43 of IPC. It means that act of criminal conspiracy includes the conspiracy of an offense or an act which is forbidden by law, which means conspiracy of an act which is forbidden by law, which is prohibited by law, and also for the conspiracy of civil cases, which is the meaning of the term illegal as provided in section 43 of IPC, which means that all the conspiracies, that is conspiracy of an offense or an act which is prohibited by law and also for civil wrongs, are included under the category of criminal conspiracies, which is included in the meaning of the term illegal offenses and which is also included or given under the definition of criminal conspiracy, that criminal conspiracy is a conspiracy made by two persons when a person or the accused person commits any illegal act or any legal act by illegal means. So here the meaning of the term illegal includes all the conspiracies of these above mentioned offenses. Third point, criminal conspiracy is a continuing offense, which means, for example, if A, B, C were involved in the whole process or all the stages of criminal conspiracy and gradually the person D got involved in the final stage of criminal conspiracy, then he will also be liable for criminal conspiracy in the same manner as A, B, C were liable for the offense of criminal conspiracy. Here D cannot plead the defense on the ground that he was involved only at the last stage of the conspiracy and was not involved in the prior stages of the conspiracy. Fourth point, that it is based on the doctrine of mutual agency, which means that criminal conspiracy is based on the idea of joint or mutual agency. So every conspirator is liable for anything done by any other conspirators in furtherance of any common objective or common object. It means that it gives the concept of joint liability. Now we will discuss that criminal conspiracy is an inchoate offense, which means an incomplete offense. As we know that there are four essentials of an offense such as human body, mens rea or guilty intention, actus reus or guilty act which is done by the accused person in pursuance of the guilty mind, an injury which can either be caused to person's mind, reputation, body and property. In addition to this, there are four stages of crime such as intention, preparation, attempt and commission or accomplishment of a crime. And if the crime is committed without fulfilling any of the requirements of an offense, it is known as inchoate offense or incomplete offense. Therefore, criminal conspiracy is termed as inchoate offense because it is punished at the stage of intention itself and it is a crime even without fulfilling all the requirements of crime. Therefore known as inchoate offense or inchoate crime. Now we will discuss that why criminal conspiracy is punished at the stage of intention itself. It is so because the law believes that the guilty intention or guilty mind of a single person is less severe. That is, it can be controlled due to lack of means or due to lack of resources or due to the failure, he can drop off the plan of committing a crime. But if two persons will conspire with each other, then they will provide encouragement and support to one another, which will increase the possibility of the commencement of a crime. This was held by the Supreme Court in the case of Devinder Pal Singh versus National Capital Territory of Delhi. Now we will discuss about the second section under criminal conspiracy, which is section 120B, which deals about the punishment of criminal conspiracy, under which clause 1 says where a person conspires to commit an offense that is punishable either by death, life imprisonment or rigorous imprisonment for a term of 2 years or more, then he will be punished in the same manner as if he had abetted such an offense. Which means that whoever is a party to criminal conspiracy, if commits an offense which is punishable with death or life imprisonment or difficult or tough imprisonment, which is known as rigorous imprisonment, for a term which is more than 2 years, is punished in the same manner as if he had abetted such an offense. Abetment means to encourage or assist someone in doing a crime, which means that if someone is being found conspiring such an offense, then he will be punished as if he had abetted such an offense. Clause 2 says that where a person conspires to commit an offense that is other than the offense punishable with aforementioned punishment, then he or she will be punished with the imprisonment for a term not exceeding 6 months or with fine or both. It means that whoever is a party to a criminal conspiracy commits an offense which is punishable not with death, life imprisonment or rigorous imprisonment for a term which is more than 2 years. It means where the punishment for an offense to which the party is conspiring is less than the term of 2 years, then he will be punished with the imprisonment for a term which is not exceeding 6 months or with fine or with both. In simple words, we can say that if a person conspires to commit an offense whose punishment is more than 2 years, then he will be punished in the same manner as if he had abetted such an offense. And if a person conspires to commit an offense whose punishment is less than the period of 2 years, then he will be punished with imprisonment for a term not exceeding 6 months or with fine or with both. So with this, we ends up with our video. If you have any suggestions regarding my video, do let me know in the comment box section. And if you like my efforts which I tried to pour in this video, do like, share and subscribe to my channel. Don't forget to press the bell icon parallel to the subscribe button in order to get notified when I will upload my further videos. So it's the time to leave now. So until we meet again, stay home, stay safe, do take care of yourselves, do take care of your families, and there's a goodbye. Thanks for watching.